So, but if you answer, that, that's when you're going to put your affidavit, your motion to deny his request for summary judgment. And then you're going to attach your affidavits. Okay, these are the reasons why the defendant does not have any reasonable cause for dismissal. You know, it's really very straightforward and it's not complicated, but believe me, that patients were so confused on this for years and years and years. Because I remember listening to shift shows years ago, and nobody seemed to know what that meant. Failure to state a claim upon which relief could be granted. Nobody seemed to know what that meant. Well, okay, it's exactly what it says. He's saying that your complaint did not have a sufficient reason. Didn't have, what's it say? Yeah, but like in the court rules, it says if this is petitioned to the court for dismissal based on that, then he has to supply the affidavits and evidence to support that 12b6 motion. Failure to state a claim upon which relief can be granted. So maybe somebody filed a complaint here. A real complaint, supposing he had everything in his complaint perfectly good, and then he did not state damages, actual damages. Yeah, so he didn't have any relief sought. Or supposing he didn't prove that the defendant's cause was the proximate cause of the damages. Supposing he didn't show that his complaint, that 12b6 might apply. That's what 12b6 is for. When somebody files a complaint that's deficient. You understand that? See? See? I'm not as dumb as I look. Okay, so that's how we have to do. There will be other things that they will try to throw in, but call them on every item.
So repeat what she was just saying, cleared it up. Say that
she said I'm smarter than that.
Oh. Oh.
You basically said the claim was deficient in some area. They pick it up and they just throw this back in your court saying,
and then they have to make, and then they make an affidavit or evidence. They'll show the complaint, say the complaint lacks this necessary thing.
Kick it out.
Kick it out, throw it out.
Do they actually specify what it's lacking, or do they just?
They should, yes. He should specify what is lacking, and he should do it by supplying evidence or affidavits to show that.
And he probably won't.
Well, wait. But we're going.
He probably won't.
Yes, he has to.
You have to go back and chase that again.
If his claim is that failure to state a claim, okay, if he doesn't explain that under that claim, you file back and you say the defendant did not provide enough information upon which a determination could be made. Now that's a denial of that. Now if he wants to go forward with 12b6 again, he has to explain that to you. What it was in your complaint that was deficient. If he can't tell the judge, the court, what was deficient in there, he didn't even have subject matter jurisdiction to do this. To ask for a dismissal, and he's perpetrating fraud in the court. And that's my take on it, because if he's making a claim, he's responsible. The lawyer is responsible for putting his signature on there and what's in the pleadings. His pleading for a motion for summary judgment based on 12b6 is a fraud perpetrated on the court. If he cannot show by affidavit or evidence that there was, in fact, a deficiency in the complaint.
Would you ignore that or add it into your...
I'd add it in. Right now, we have to add it in. The court could sanction a lawyer on its own anytime they want. But what we want to do, what we have to do, is put the judge's feet to the fire. This is not a case of us being nice to the judge. Kathleen knows about that. Half the people in this room know about what happens when you try to be nice to a judge. They ignore you. They allow fraud to go into court. They allow the lawyers to do anything. They put all kinds of restrictions on you. They favoritism, cronyism, all that stuff. So we have to be tough with them.
Do you think that Larkin was too nice to the judge?
I have no idea. I wasn't there.
Oh, I was just wondering. Because the messages that I got back from him, he said, well, we have to see what the judge is going to allow in court. And, you know, a lot of times it was just like certain laws and stuff he's kicking out.
See, I don't think Larkin knew anything except that 861 argument. He didn't know how to go to court, what the court rules were, nothing.
He does have Larry Beecraft assisting.
No, Larry's like a standby lawyer.
Yeah.
Larry is not sitting in the court, he's not advising him, he's a standby lawyer. Larkin was representing himself, right?
Right.
Okay, so Larry probably wasn't even consulted.
But he's saying that his wife is going to have an attorney.
Yeah, I know. Oh, going to have an attorney? Okay, well, good for her.
Good for her?
Well, because she'll do better with an attorney than Larkin did. Yeah, Larkin didn't know anything about going into court. He was incompetent. All he knew was a one-string banjo, 861.
Why ain't he sitting here in class?
What?
Why ain't he sitting here in class?
He should be.
Same reason.
Hey, you know what?
He's got an ankle
Because he's in
bracelet on
trial
him.
right now.
Huh?
Same reason.
Because he's in trial right now.
Yeah, right, exactly.
No, it's over.
You know, I sent Larkin all my stuff. I sent him a ton of stuff. And you know what? He never even answered me. Never would answer me. I said, here, use these court cases. Use U.S. versus Bishop. Never would answer me.
I even forwarded stuff to him from you.
I had guys...
I got an email from Watkins, and he says that he's found guilty on 4 counts.
Yeah. Yeah, we know that, but the fact was that Larkin wouldn't prepare himself. He probably doesn't even know about 12b-6. Oh, well, no, 12b-6 wouldn't apply to his criminal prosecution. No. But I mean, he doesn't know how to, rules of evidence, rules of witnesses. He probably didn't have any witnesses come on the stand for him. He could have asked me to be a witness. Anyway, you can't do anything for a person. You know, I see this in people in our groups. They're going to resist. I know what I'm doing, and then bingo, they're in jail. That's what happened to the guy in Hawaii. A very nice guy. I talked to him on the phone several times. I gave him everything that I had, you know, at the time. And he wouldn't rely on the Supreme Court rulings. He wanted to rely on that name on the paper is not me. I'm a flesh and blood person. You have no jurisdiction over me because that's not me. Trying to convince the jury of that. Yeah.
It's a very foolish thing to get a lawyer because when if he is knowledgeable about this stuff and he confronts the lawyer with it, the lawyer will get peeved and he will claim breakdown in communication.
Yes. Yes.
And at that point, he'll motion the judge, there's a breakdown of communication, I'm dropping out of this case.
Right.
And then you have to pay this lawyer thousands and thousands of dollars.
That's what I'm afraid of with Larkin's wife, if she's going to...
Yeah, but how is she
foolish
going
to
to
do it.
defend himself? I'll bet you she's less knowledgeable than Larkin is. I'll bet you she was depending on Larkin getting clear of everything. I'll bet she was depending on that. And now she's stuck. You can work yourself into a box that you can't get out of.
Well, I think that's why everybody feels like they're in a catch-22. Well, you want to go pro se, but you don't feel that knowledgeable about what to go into, you know, how to do it. And
Yeah, but here, it's not a bad situation if you're willing to file the paperwork and you know what the court cases say. You're going to have Supreme Court rulings like that federal maritime where the judge has to explain all the issues. So if you make a motion to dismiss, if you make a dumb motion to dismiss, the judge is going to dismiss it. But if you make a very accurate and truthful motion to dismiss the case, oh, you can.
I'm gonna go with this.
Well, we're about done anyway. Why don't we just, I'm sorry. We'll get here tomorrow. I'll see you tomorrow morning.
Hey Chuck, wait a minute. Bill wanted me to pick these things up if you're not, taking them home because he wants to use it. These are the court,
Who's this?
the case.
Oh,
Unless you're going to bring them back with you tomorrow.
what is that?
Yeah, why